Hello, my name is John Vermillion. I am an elder law attorney and estate planning attorney in Dallas, Texas, and I'm one of the sponsors of the Elder Care Channel. And today I want to talk to you briefly about the effects of dementia and Alzheimer's when it comes to executing estate planning documents. As most of you are aware, we have a population that is continuing to age. We have more and more people who are reaching what we call the senior years and living uh, quite a bit longer than we've ever experienced in the past. Now, we've had more and more occasions because of the fact that we have more and more people living longer of people who are incurring dementia or Alzheimer's. It's not because there's a virus going around that is causing these conditions. It's because more and more people are living to an age where the conditions of dementia and Alzheimer's are often seen. Now, we know when we execute estate planning documents, which include wills, trusts, powers of attorney, that we have to have what's called mental capacity. And mental capacity is the ability to make decisions, to understand the nature of the documents that we're signing, and to know what they do and how they affect us. Um, Mental capacity is not something that is either 0 or 100%. It's kind of a continuum. We know that some people are fully capable and some people are fully incapable of making decisions and understanding the nature of the documents they're signing. But what about all those people in between? It's kind of a gray area. And so somebody who's been diagnosed with dementia or Alzheimer's may still have sufficient mental capacity to execute documents. It becomes a decision based on the facts of each individual situation. Uh, a client does not have to have 100% mental capacity to execute estate planning documents, but they do have to have sufficient mental capacity at the time that they execute the documents to know what they're doing and what the effect of the documents is. Um, Often we call this a lucid interval. Now, in family situations, one of the biggest causes of dispute occurs when one family member will have a parent sign estate planning documents, perhaps at a time when the parent is suffering from some level of dementia or Alzheimer's, that provides preferential treatment to that particular child or provides that that particular child will be the caregiver or the decision maker. And other family members may disagree with that and claim that the parent didn't have sufficient mental capacity. So what I always want to encourage clients to do is A, get their estate planning done as soon as possible. It doesn't matter whether you're 25 or 85. It's important to do at any time, but more important as we get older to do it before we can ever have an allegation of mental incapacity. We have clients who've been diagnosed with early stages of dementia and Alzheimer's who still have mental capacity sufficient to sign legal documents, and we encourage them to get in to see the attorney and get those documents prepared while there's still no question as to their mental capacity. So dementia and Alzheimer's can have a very negative impact on estate planning, but all is not lost if estate planning is pursued at the early stages of dementia and Alzheimer's. We have resources on the Elder Care channel to find information about both conditions, and I encourage our listeners and our viewers to access that information at any time, and just as importantly, to seek the counsel of an elder law attorney or estate planning attorney at the time of need. This is John Vermillion. I hope you found this information to be helpful.